Everybody, welcome. My name is Anthony Niblett. I am a professor at the University of Toronto Faculty of Law. I'm also the academic advisor to the Future of Law Lab. The Future of Law Lab is designed to bring together students, academics, practitioners, entrepreneurs, policymakers to discuss some of the big issues that are going on in law, innovation, and the digital economy. Today, we are talking competition policy and we are talking privacy. Now, I am no expert on the intersection between competition and privacy, but fortunately, I know people who are, and I'm delighted to be joined by a couple of academics whose work crosses both fields. And so I'd like to introduce Erika Douglas, who's a professor at Temple University, Beasley School of Law. We are right in the wheelhouse of Professor Douglas's research interests, which include antitrust, privacy, and IP. Although she works in America, Erika is Canadian. Welcome, Erika. And we've got Francesco Ducci, a professor of law at Western Law. Professor Ducci's research investigates the nature of market power in big tech sectors and the role of competition policy and regulation in digital markets. So we're here to discuss competition policy and privacy, and the federal government is currently conducting a review of competition policy in Canada. This is the ISED consultation report, and privacy features in a number of different ways in this report. Noticing that the nature of competition is changing, that a number of companies in the digital economy give away their products for free in terms of dollars, but consumers are required to give up some of their privacy. And so there are questions about privacy safeguards in here, about how that becomes a dimension of competition. There are questions in here about how best to administer these multifaceted responses. Should we have a bureau that takes into account not just the traditional aspects of competition, but also issues of privacy, perhaps things like security and disinformation? There are questions of privacy that come up when we talk about data mobility. And there are questions of privacy that come up when we talk about things like mergers. And we know that privacy is less quantifiable than some of the other attributes in competition. It makes it hard to judge some of the efficiencies in mergers. Pops up in a lot of different places. And so lots of big issues to talk about. And if I can turn to Erika first, we've probably got a lot of competition practitioners, people interested in competition on the line. And so I wonder if it might be helpful just to start off with just a high-level overview of digital data privacy, privacy law, and perhaps why it's become such a hot topic in the past decade or so.
Thanks so much, Anthony, for hosting us here today. I'm not only Canadian, but practiced law at Davies for quite a while. So it's always a joy to talk to Canadian audiences. It feels like coming home. So I think a fair preliminary question, we've already thrown you into the deep end, but a fair preliminary question is, what does competition have to do with privacy at all, or vice versa? And so I'm going to share a couple of slides because I think to understand what they have to do with each other, it really helps to be specific about what we mean by privacy. So privacy is a notoriously broad concept. Privacy scholars are obsessed with asking what privacy is. When we say privacy here today, I don't mean decisional privacy in the sense of the Dobbs decision or the Morgenthaler decision. I don't mean spatial privacy in the sense of kind of unreasonable search and seizure. What we're really talking about is data privacy, sometimes called informational privacy, or if you switch countries, data privacy. And it's the power to control your personal data, how it's collected, how it's used, how it's sold. And that form of privacy is protected primarily by PIPEDA in Canada, although as we'll hear from Francesco, that's about to change with Bill C-27. And in the US, data privacy law really means enforcement of Section 5 of the FTC Act by the Federal Trade Commission and enforcement of a handful of other laws we have, like the Children's Online Privacy Protection Act, and now increasingly state law. And these laws all sort of focus on affording privacy through notice and consent. So companies are obligated to give individuals notice about what they will do with personal data, and then to seek consent from those individuals to the terms of that data processing. And so the onus is on us as individuals to make choices about our data privacy. And provided that notice and consent occurs, firms are generally free to do what they will with their personal information consistent with the notice. And there's really been a tidal wave of data privacy law over the last 5 years. I think that the number of people here to hear about this intersection speaks to the fact it's become part of all of our practices. The European General Data Protection Regulation came into effect in 2018, and that really brought privacy to the forefront of business and legal decision-making around the world. The US now has 5 states with what you might call mini GDPR laws that provide data protection. And there's 130 jurisdictions by last count, at least around the world, that have some form of data privacy or data protection legislation. And I think of the developments that we see in the law now as really coming from what was happening in commerce in the late 1990s. People were putting their data online for the first time in massive quantities, kind of the heyday of eBay and PayPal. That's where all this privacy law came from. US Congress really realized that most of that information online was unprotected, and it encouraged the Federal Trade Commission to use its Section 5 powers to provide some sort of consumer protection for that data. And so all to say, I think thinking of data of privacy in this sort of narrow sense of data privacy helps to understand this slide of why it intersects with competition. As Anthony was saying, in the digital economy, the nature of competition is such that many goods and services use our personal data to compete. Okay, it's the fuel of competition for things like social media, where your posts fuel Facebook, or searches, where your searches fuel Google, and your location data for apps. It's a lot of our personal information and analysis of it that makes competition possible. And so that's the same personal data that data privacy law is starting to control. The Economist once said that data is the new oil. If that's true, then privacy law is really OPEC. It's controlling personal data around the world. And so there's this new realization we're seeing about how competition and privacy overlap in a kind of Venn diagram. Both of them work to promote consumer choice in markets in different ways, and both are concerned with the effects of corporate power and digital trust. And so we see developments like the term privacy suddenly appearing in the Competition Act through the BIA amendments. We can talk more about that. And there's a new awareness in the US as well. So the head of the FTC here has identified a desire to understand this overlap as a priority in testimony to Congress. And as we jump ahead into sort of how to understand this overlap, I like to think of it as having sort of 3 types of interactions. So this is what we're seeing so far. And this is just our map. I won't delve into them right away, but what you might call defensive theories, where privacy is being claimed as a business justification by a company in antitrust litigation. Offensive theories, where an agency or private plaintiff is claiming that market power has been used to erode data privacy, and then sort of remedies and legislative interventions.
Super. Thank you very much, Erika. You mentioned Bill C-27 in your comments. I wonder if I can turn to you, Francesco, just to give us a bit of a high-level overview of what's in there, and then we'll take that and we'll come back to discuss those 3 intersections that Erika just mentioned just then. So, Francesco.
Perfect. Thank you, Anthony. So in June 2022, the Canadian government introduced Bill C-27, also known as the Digital Charter Implementation Act, which might change the privacy landscape in Canada. And the package includes 3 important updates, innovation changes that I want to briefly emphasize. The first one is a potential update to Canadian privacy law, so replacing PIPEDA with the Consumer Privacy Protection Act, also labeled CPPA. In a nutshell, this piece of legislation would enhance the paradigm of consent by requiring organizations to provide information about the purposes of data collection, the type of information that are collected, but it also includes several exceptions, including a notion of legitimate interest that will probably become controversial, but quite important going forward. This piece of legislation also enhances the rights of data mobility and data disposal for users. In addition, there is the creation of a new specialized tribunal that is focusing on privacy and data protection. And this tribunal will have the power to impose significant penalties, including administrative monetary penalties up to 5% of gross annual revenues of the organizations involved. And the third piece that is included in the package is the first comprehensive legislation on artificial intelligence, which, among other things, would proposes to create an oversight regime for high-impact artificial intelligence systems, with a view of to prevent harmful effects and also biases that might emerge from the use of AI technologies. So all these three pieces together might change the landscape of privacy regulation going forward.
Thanks very much, Francesco. Erika, in her comments, referenced three ways in which privacy and competition intersect. These three are detailed in more detail in an excellent report that Erika wrote a couple of years ago called Digital Crossroads. It's a fantastic read. And maybe what we can do is we can dig into those three. If we want to focus first on privacy as a business justification, this idea that, one way of thinking about this is potentially you act in a way that's anti-competitive, or there's, it looks anti-competitive. Perhaps, you're limiting access to data, you're raising barriers to entry, and you justify this on the grounds of privacy. You're using privacy as a business justification. Now, as a justification for potentially abusing your dominant position. And this raises all sorts of thorny issues. And so potentially I'll turn to you, Francesco, first to talk about how we've seen that play out in the Canadian context, how we've seen privacy being used as a business justification here in Canada first.
Perfect. Yeah, so TREB is a very important abuse of dominance decision for two reasons. One is a case that revolves around data, if you want, in a pre-big data world. And second, there was this issue of privacy as a potential defense, potential business justification for otherwise anti-competitive behavior that emerged from the case that might give us some guidance on how case law might develop in the future. So TREB, essentially, just to give some background, operated a multiple listing service, essentially an online database for the collection and distribution of real estate information to brokers that were members of the association. And TREB allowed the members to share the data through various means, but also imposed some restrictions that prevented brokers from giving clients access to some of the data when the services were provided virtually through the so-called virtual office websites. So the commissioner argued that these restrictions created a disadvantage for these innovative brokers that would prefer to provide services digitally. And this resulted in an abuse of a dominance position under Section 79 of the Competition Act. TREB's response was that this restriction did not substantially lessen or prevent competition, but also that these restrictions were justified on the basis of privacy concerns. Now, what's interesting from this decision is first that the Competition Tribunal and the Federal Court of Appeal rejected these arguments. It was clear from the evidence that these privacy justifications were simply an afterthought for TREB. There was no evidence that TREB was actually motivated by these privacy concerns. And there was no evidence of violation of TREB's responsibility under PIPEDA's privacy regulation. At the same time, we see a recognition, especially from the Federal Court of Appeal, that privacy consideration might serve as a valid justification for an otherwise anti-competitive act. But this is possible only when there is a credible efficiency or pro-competitive rationale for the practice. So while the privacy arguments did not succeed before the Competition Tribunal on these particular facts, given that the board really failed to provide evidence of privacy concerns as being the motivation for the restrictions to data sharing, this case will serve as a basis for privacy considerations going forward, especially when we see the use of data as being justified from a privacy perspective.
Yeah, thanks, Francesco. So yeah, so we've seen it pop up superficially in the sense that the privacy wasn't driving TREB as their actual justification, according to the tribunal. But when we actually see it play out in practice, when people are genuinely motivated on trying to justify on privacy accounts, we're going to have to grapple with this problem of, well, we've got these competing objectives here, and which one takes primacy over the others. These are the kinds of issues that have already popped up in America. And I wonder, Erika, if you can speak more to generally how this business justification has played out in the United States, if you want to talk about potentially the Epic and Apple decision.
Sure. So before we leave TREB, I'll emphasize sort of two takeaways that I see from it. I mean, first, so when I worked at Davies, I had a partner who loved reminding our American clients that Canada passed the Combines Investigation Act a year before the US passed the Sherman Act. And TREB's another example of this, where Canada was first. So I regularly use the TREB example. It's one of the earliest cases to consider this argument that privacy might be a business justification. And I think that as a jurisdiction that has strong privacy law and relatively strong competition law, Canada could continue to sort of be first in this space, although it hasn't been paying much attention to this since TREB. And second, I just want to emphasize that sort of TREB's privacy arguments failed because they lacked evidence. And so it's important to kind of separate the law and the facts, and the decision, like Francesco said, is pretty open to the idea that data privacy could be a justification, that the law doesn't preclude that at least. But the takeaway is that the documentary evidence is going to be important. What does it show about the defendant's conduct? And so in that sense, this is a new topic for a lot of attorneys, but it's actually a pretty familiar topic for competition lawyers, in that the internal documents are going to play a significant role in what the defendant can prove. And so if we turn to what Anthony mentioned, sort of the leading US case, it has the same procedural posture as TREB. So a claim of anti-competitive conduct against Apple, and Apple argues that its conduct is justified because it was meant to protect user privacy, so the privacy of you and I. And TREB rejected the justification, but the argument was accepted in Apple. So it's a high-profile case before the Northern District of California in 2021, and it's on appeal now to the Ninth Circuit. The hearing was in November, so we're waiting for a decision. But just a couple of words to understand the case. Epic is a video game and app developer. It distributes, its most familiar game is probably Fortnite, and it distributes through the Apple Store, where you go to get your apps if you have an iPhone. But Apple removed Epic from the store because Epic was not following these limits and rules that Apple placed on payment and distribution of apps. You have to use Apple's payment software, and you cannot distribute to consumers outside of the Apple Store. And so Epic was violating those rules. And Apple's App Store is the near exclusive source of app downloads for Apple. And so that's important to understand the case. Epic brought state and federal antitrust claims. I'll focus on the federal ones. And Epic was actually successful in showing that Apple's conduct was anti-competitive. That's difficult, right? It's often difficult for plaintiffs to get past that first burden, but Epic did. But Apple wasn't ultimately held liable by the lower court because it showed that its conduct was justified based on privacy and security. And it really had sort of two justifications. Its rules for the apps that appear in the App Store keep it private and secure, so consumers can trust what they download from the App Store. And second, because consumers can trust what they download from the App Store, Apple is better able to compete with other mobile operating systems like Android, okay, Google Android. And so I argue in a recent article with Notre Dame, that's only half right, which gets back to sort of what Anthony was talking about. I think if we understand the theory of justifications correctly, then privacy is only a justification if it also improves competition. Okay, so the nexus to competition is sort of the key to establishing this in at least US law and I think Canadian law too, because competition law says competition is good for consumers. It doesn't say competition is good for consumers, but except for privacy, it just says competition is positive for consumers. And so that resolves a little bit of the tension here if we get the law right on business justifications. Privacy related to competition is a justification. And so the Apple case is really a prime example of that. It's definitely one to watch as it goes ahead. It's sort of the leading case in the US. But a lot of other platforms, so digital companies, are making this argument. Google has made a similar argument. LinkedIn has litigation where they've made a similar argument that they want to foreclose rivals to protect privacy.
You mentioned Google, and yesterday there's some discussion with regards to the DOJ coming back to Google with relation to their merger from 2007 with DoubleClick. Just wondering if you can talk a little bit more about that, Erika.
Yeah, it's making a lot of headlines here in the US. So the Department of Justice Antitrust Division has an existing case against Google from 2020 that's about search and search advertising. And then yesterday, so timely for this panel, they filed another major case against Google that relates to advertising technology. And it's interesting from a privacy and competition perspective because this conversation we're having today goes back to 2007 when Google acquired DoubleClick. DoubleClick is an ad serving company. And at that time, there were a lot of privacy advocates who were trying to get the FTC to block the merger on grounds that it would be negative for consumer data privacy. And the FTC made a really important distinction that kind of echoes the distinction I was making for justifications, which is antitrust law can only address privacy if it relates to competition. So if there's a market where companies are competing to provide privacy to us, to provide better settings or more features or less ads, then that's something that would be considered in a merger. But we're not going to use antitrust law just to protect privacy generally. You know, that's sort of having a hammer and thinking everything is a nail. That's a separate argument just to say antitrust law should protect privacy. And so now in the DOJ case, we see the same merger come up again. It's part of the allegations now that Google is engaging in anti-competitive conduct in the ad ecosystem, even though it was reviewed by the FTC way back when.
Okay, wonderful. So let's change gears slightly. We were talking about defendants using essentially privacy as a justification for their anti-competitive conduct or alleged anti-competitive conduct. Let's shift gears to the more offensive uses of privacy. And what we've seen is privacy being explicitly added into the Competition Act as a feature of quality, essentially. That is a dimension of quality. And so, Erika, I'll turn to you first. I was just wondering if you could talk a little bit about what you've seen in the United States with regards to this, of how this is being used on the offense.
Yeah, and I think it's the main theory and way that antitrust has understood privacy, the competition law has understood privacy, is that it is a non-price parameter of competition. So in some markets, companies will compete based on privacy features. And this is coming up, so I talked about the DOJ's new case, it's coming up in the DOJ's older case from 2020 against Google, where the claim is that Google used its market power to erode privacy in search. Okay, and there's a parallel claim kind of in the FTC's 2020 case against Facebook, which is also ongoing, that Facebook used its market power in social media services to erode privacy quality, to kind of offer users less privacy options, to have a higher load of advertising, and to reduce sort of the variety of privacy protection options below what we would see in a competitive market. And so that's how it's kind of being used as an offensive theory. It's probably not the exact right word, but as in claims against large technology companies. And so that's how in Europe too, kind of privacy has been understood within the rubric of existing antitrust frameworks. I think the challenge, if we come back to your comments on the BIA, is that it bifurcates privacy and quality. If you look at the terminology, it's added privacy as a factor to be considered in abuse and merger cases, but it says quality or consumer privacy. So if quality is different from consumer privacy, what does privacy mean for the antitrust competition law context? And I don't have an answer for that, but that's part of the challenges kind of I see with the amendments that were just passed. It leaves a pretty significant unanswered question about what privacy is if it's not the basis of quality in a non-price way in a market. And so this is also part of the consultation from ICSED, is asking sort of how do privacy and competition interact?
Yeah, so I guess this is one of the big question, which is to what extent is privacy and quality pushing in the same direction? Does it always, is there a presumption here that more privacy is a higher quality? I mean, you can imagine some sort of arguments that suggest, you know, there's a trade-off here, that we actually need information in order to make products better. We need some information in order to provide, better pharmaceuticals, better product experience, all sorts of things. That there's actually a trade-off here, and they're not always pushing in the same direction of privacy and quality. Francesco, I just wanted to turn to you for your reactions to how we might be taking this into account here in Canada.
Sure. So just to connect to what we were just discussing, I agree with Erika. There is an ambiguity in the reforms, because we see privacy as a dimension of quality, but also potentially as a standalone goal, at least as the amendments have been drafted. And I think this is potentially problematic, because when we look at the trade-off that you were mentioning between sort of price competition, quality competition, there is a quite wide range of arguments that could be raised following TREP, but we have some guidance, for example, that can come from vertical restraints. In many areas of competition law, like vertical agreements, we see this tension of private competition or restriction of private competition because of privacy or enhancing services. So there is a basis already in the competition law, case law, and literature to how to think about analogize from what we know in the context of privacy. This is different from treating privacy as a standalone objective that trumps other sort of economic goals. I would say here, I tend to favor a narrower view of privacy, more as a price, non-price dimension of competition, to the extent that there is an efficiency of pro-competitive argument there. But if you want, I can also mention another offensive theory of harm where privacy is used that comes from Germany and Europe, where the step seems to be even more aggressive in the use of privacy as a justification. Would you like me to address it right now? Yeah, so there are these two very unconventional cases that come from German competition law. One against Facebook, and the second one from a couple of weeks ago against Google. These are unconventional for two reasons. The first one is that this type of cases would not be captured under the Canadian Competition Act, because they focus on exploitative use of market power as a basis for abuse of dominance, as opposed to exclusionary conduct. So Section 79 of the Competition Act only applies to conduct that is exclusionary, predatory, disciplinary, but essentially something that excludes or tries to exclude. There is no mention of exploitation of market power, the classic example being monopoly pricing. German competition law includes exploitation of market power as a potential abuse of dominance. And the classic example is, again, monopoly pricing, but the equivalent can also be a degradation of quality because of market power. So German competition law, competition authorities are using this exploitation as of market power as an abuse. And they're using the violation of GDPR, so privacy regulation, as a benchmark to decide what it means to be engaging in exploitative abuse of market power. So in the Facebook case, for example, the German Federal Cartel Office argued that forcing users to give consent to the merging and combination of personal data within the social media platform that Facebook provides and beyond it. It was an exploitative abuse of market power because it was a violation of GDPR. And a similar theory of harm has been applied in the more recent Google case, where the complaint is that users are not given sufficient choice to decide the extent to which data processing is allowed. And because Google has this entrenched, according to the theory of harm, dominant position, the violation of GDPR provisions provides the basis for exploitation of market power. Now, what's interesting is that it's not clear where this is going, because the German courts have referred the Facebook case to the European Court of Justice, which will rule whether this theory of harm is consistent with European law. But we do have the opinion of the Advocate General of the European Court of Justice, which essentially is not binding but highly persuasive for the court. And there seems to be some pushback against this theory of harm, but I think it's useful to mention what the language is like. So there is mentioned that an incidental consideration of privacy regulation is admissible in competition law cases to the extent that it's part of the wider scope of legal and economic sort of context surrounding the conduct. So when we're looking at the sort of, is this competition on the merit, violation of privacy regulation can be considered as an incidental consideration. But the Advocate General suggests that a violation of GDPR cannot be a standalone motivation for violation of Article 102 or abuse of dominance in European competition law. We don't know whether this argument will be followed by the European Court of Justice, but this is another example, even more aggressive example of how privacy could even be used as a basis to find an infringement of competition law. And this is happening in the broader context where European Union is moving toward ex-ante regulation. A lot of provisions that are included rely on data portability, interoperability as a way to promote competition in digital markets, and this will create obvious questions with privacy, because to the extent that we want to promote competition through portability and interoperability, there will be questions about the privacy implications of this type of regulations.
Yeah, thanks, Francesco. I think you framed it really well, that this wouldn't be something that pops up in Canada. And I think a bigger question that people might have is, to what extent is this really to do with market power? So, we're accusing some of the digital giants of excessive data collection, or of invading privacy through obfuscating the terms or something like that. And so I'm wondering, to what extent is this market power, or is it asymmetry of information? Does it really rely on market power? I'm just wondering what your reactions to those sorts of views are.
Yeah, so I see this type of cases that come from Germany as really, really beyond standard competition law. So I'm a little bit skeptical about this theories of harm. I think so as it applies to the Canadian context, I would not favor a shift in this direction. But I see what the German competition authority is trying to do. So essentially, given that exploitative abuse of market power is part of the law, there is a question if it's already hard to apply exploitative abuses in monopoly pricing cases. What is the monopoly price compared to the competitive price? This is even harder when we are dealing with privacy as a quality dimension. How do we quantify this quality dimension as something that triggers an exploitation of abuse? I think this is, in a way or another, a way to solve this quantification issue within the legal framework that exists in some of the European countries, to say we don't know how to quantify this privacy degradation through quantification. So we are going to use privacy legislation as a benchmark. I think this is a big stretch, but this is, I think, what's going on behind these cases.
You can cast the cases a little bit more skeptically too, I think, Francesco, and that the privacy law is hot right now, and the competition agency was interested in bringing a case, and they based it on privacy. I think what it does have in common with what we're seeing in American and Canadian law is this idea that companies might extract more data than they would in a competitive market. But I think, Anthony, you ask a good question. And small companies violate privacy law all the time too. So is this really causally related to the monopoly power and the conduct that's being alleged as anti-competitive in the sort of German cases that we're seeing? I think it's worth noting too, like we haven't seen even other European countries bring cases similar to the German competition cases that Francesco's talking about. So they're still sort of standing out there on their own. They brought a second one now against Google, but the one against Facebook hasn't actually been successful yet. It's at the European Court of Justice. So I think there's a big question mark over all of that litigation and whether those theories are going to hold even in German law.
Yeah, and I would, if I can add, Anthony, I think that the economic concern behind these cases seems to be based on an assumption that some of these platforms have an entrenched market position. So there is not just market power, there is an entrenched dominance that is hard to displace. And so the concern about exploitation of market power, I think, seems to be based on this assumption that market forces will not constrain market power on its own, which is something that is in itself an open question.
Mm-hmm. Yeah, so if we're thinking about theories of harm, you're saying that the potential harms here don't fit within the way that competition lawyers might think about these theories of harm. But privacy lawyers would be saying, oh, there's lots of harm here. And so then the question is, how do we weigh up these different types of harms? And are competition authorities actually in a good place to be able to measure these two different things? How do they balance these two different types of harms? How do they think about which should get primacy? And Erika, if I can turn to you, I mean, you mentioned earlier that there's actually a way of combining the two, that you can actually think of it as through the lens of the consumer. Just wondering if you could just flesh that out just a little bit more for us.
Yeah, I think it's fair to sort of start with the idea that maybe it's not up to competition authorities to get privacy right. Like maybe this is a bigger policy question, sort of comprehensive digital policy, things like the digital charter that consider both competition and privacy at a legislative or policy level, kind of up one level in the food chain. But I think that what is actually important is that each authority is aware of their potential impacts on the other area of law, at least enough we know there's lots of ways agencies cooperate. Maybe they have a consultative obligation or a duty. And we're seeing this come out in the UK. They're considering imposing a duty on privacy authorities to at least consider competition, which to your point on agency competency might mean going to the competition authority and saying, what do you think about this action we're about to take? So I think there's a question of agency cooperation at that level. And then I think there are bigger policy questions that we're mixing them together a little bit just to say that. And I think what you mentioned about consumer choice, I think has really been sort of the core commonality we've relied upon for privacy and competition to be similar and compatible. And that was the narrative for a long time. These are two areas of law that are horses that are pulling in the same direction. But privacy law at its very edges, and I don't want to overestimate that, but at its very edges is starting to say maybe consumer choice isn't enough. Maybe when we just ask and give notice and consent, that might not be enough to protect consumers. And so there's sort of a shift towards more prohibitions that say you can't do this with data. An example is in the US, Illinois prohibits the sale of biometric data, so retina data, fingerprint data, facial rec data. You can't sell it. So taking competition out of the equation entirely. And I'm not necessarily advocating for that, but I think there's some realization that competition might not always drive optimal levels of privacy, so privacy regulation might have to intervene. And where that brings antitrust law is towards maybe more thinking of privacy like it has regulation, right? Telecommunications regulation or other areas of regulation where antitrust law isn't enforced as strongly or sort of is a little bit more around the edges because there's a regulatory regime that displaces competition.
Yeah, and here in Canada, we have the regulated conduct doctrine, which basically puts competition below. Things trump competition. If we have, these privacy harms being regulated, will they just trump our competitive concerns becomes a question. And whether the way forward is not to have one trumping the other. Maybe there's a better way forward of working together. And I know you've thought about how the agency cooperation in the United Kingdom. I was wondering if you would just talk a little bit about that, Erika, for us.
Yeah, I think there's a number of global efforts to cooperate between these areas of law. And I think that the UK is probably the leading example and certainly comparable to sort of Canada's agency structure. So the UK Competition and Markets Authority, which is roughly equivalent to the Bureau in Canada, has been paying quite close attention to this interaction between competition and privacy law. There's a memorandum of understanding now between the competition agency and the privacy agency in the UK. And they've also conducted their first joint investigation into Google's changes in its cookies policy. So right now, if you use Google's Chrome browser, companies other than Google, so third parties, can track what you're doing online, the websites you visit, what you hover over, what you click on, and what you buy. And these third parties sell advertising in competition with Google. So Google announced a significant plan to terminate all third-party cookie access on Chrome. So in other words, third parties can't track us anymore on Chrome. It sounds like a potentially positive development for privacy, right? By default, fewer companies are collecting and using our information through this browser. But instead, it drew the attention of both the antitrust authorities and the privacy authorities because the concern was that data was going to be sequestered within Google's control exclusively. So other companies wouldn't be able to access data used to sell advertising in competition with Google. Tracking doesn't go away, but tracking becomes all Google's power and responsibility. And so that joint investigation actually ended in commitments from Google to ensure continued third-party access to data for ads in a privacy protective manner. And I think that's sort of where this dialogue is going. How do we seek to reconcile and achieve both privacy and competition together? And I don't think we're there yet, so it feels like there's tension here, but the best solutions are kind of seeking to do both. And there's lots of other examples. I'll just wrap up with a couple of other initiatives around the world. So the European Commission has something called a digital clearinghouse that was established in 2017, and it's a structural entity designed to facilitate cooperation and information sharing between competition, privacy, and consumer protection regulators. And actually, the Canadian Office of the Privacy Commissioner is doing a lot of work through the Global Privacy Assembly, which is a group of all of the heads of privacy agencies around the world to help different countries understand how these areas of law interact. And I think we can definitely sort of practice takeaways. You can definitely expect to see more agency cooperation and more sort of cross-doctrinal matters, particularly if Bill C-27, which Francesco spoke about, passes. There's going to be more information sharing, I think, between competition and privacy agencies and more joint investigations.
Okay, fabulous. Thank you. If I can just go back to your introductory remarks, you said there's three ways in which privacy and competition intersect. We talked about privacy as a business justification when there's some alleged anti-competitive behavior, number one. Number two was privacy as quality. And so when we're on the offense, we can actually look at whether there is less privacy and less quality. And then there's a third way you mentioned, which is the interaction between privacy and potential remedies. And I just wondering if you can flesh that out for us a little bit, Erika, just to talk about, how it is that potential remedies will actually influence or affect privacy here.
Yeah, so when we're talking about remedies in competition cases, and also I think legislation that's being passed that's intended to promote competition in the digital economy, both of those are going to have impacts on privacy. A lot of the conversation in the competition context, a lot of the discussion about behavioral remedies for the big sorts of digital platform cases that are being brought now, like the Google case that I talked about and the Facebook cases that I talked about, the remedies that's typically thrown around is requiring these platforms to grant access to third parties, interoperability, which means access to our data and information on those platforms, right? So we see this in jurisdictions like Australia and the European Union and the UK, all of the conversation around digital gatekeepers of the sites of competition, where their market dominance is seen as being used to exclude third parties. And so the remedy is allow those third parties on. There's a big change here from old antitrust remedies to new antitrust remedies, because we've granted access to data before, right? Behavioral remedies have been granted that require the defendant to give access to data. And sort of a big example of that was the Microsoft case around 2001 in the US. They had to disclose their application programming interfaces, their APIs, to allow interoperability. But that was all company information, right? That was access for third parties to company information. And the big shift now is it's access to personal information of individuals if there's interoperability with these platforms. The other big change is the rise of data privacy law. It's kind of bringing us back to where we started. Data privacy law has expanded dramatically. So even if those old antitrust remedies had involved personal information, there was no law that prevented that from being shared under an antitrust remedy. Now there is. And so we see the situation where there's this co-control, if you will, over information. The company that holds the data and controls access for third parties on a platform, and then the control that I have over notice and consent to my information. So how do we design a remedy? Do my rights as an individual in privacy extend to antitrust remedies at all? That's sort of a first question. And then a second question is, do we ask, if they do we ask for consent from individuals for disclosure of their information? And that has been the model in a case around 2008 in the US, which was also a realtor platform where there was an opt-out mechanism. If you didn't want your home data, it's a lot like Treb, if you didn't want your home pictures online, something that seems the norm now, you could opt out of the remedy that was granted in antitrust law against this realtor platform. But that makes remedies a lot more complicated. So how do we design for both privacy and competition as we look at these data access remedies that seem to be the answer in a lot of the digital debates?
Anthony, can I
Please.
I think Treb is, again, really a key case here when we think about remedies, because in that scenario, again, we are dealing with data that is used by brokers. The remedy is an access remedy. Is very simple. You can use the data no matter whether you're providing services online or in person. But if we think about a similar case going forward, where the data set is much larger, where the type of users involved are final users, the remedy will be much harder. So the remedy issue is again another important new question that is at this interface.
Yeah, great. Thank you very much. I'm a little mindful of time. So actually, with the last few minutes, what I'd like to return to is the consultation. And so, as I mentioned in my brief introduction, the privacy is mentioned a few times throughout the consultation from ISED, noticing that that privacy is something that consumers give up, and there's a trade-off there. They lower dollar value, higher they give up their privacy. There's questions about to what extent this should be a multifaceted response from different agencies, or whether it should be privacy coming through the Competition Bureau. The question of privacy comes up when it comes to data mobility and interoperability, and the question of what we do with mergers and efficiencies defense, given that privacy is so difficult for us to quantify. I just wonder if there's any overriding conclusions, some general thoughts and some guidance that you would want to offer to the Canadian government as we start thinking about how we potentially drastically change the way we think about competition policy in Canada, and how the extent to which privacy should come into it. So just some high level thoughts and advice. I'm going to start with you, Erika, perhaps.
Sure. Start with the American for the Canadian policy. So I think the big message here is that there's a need for more interagency cooperation, and I don't think that policymakers in Canada are unaware of that. I think they're starting to see this. privacy is changing its identity in law from something that's notice and consent to something that's stronger, right? And that's what C27 is doing. It's giving privacy this more gravitas in law. It's rights now. It's something that can't be ignored. And so that is going to mean that agencies have to grapple with it on both sides. So the Bureau and the Office of the Privacy Commissioner are both going to have to deal with each other's areas a lot more. And I think that's it's a big challenge in kind of operationalizing that, because the language is very different. The paradigms are very different. For example, already competition law in Canada is talking about consumer privacy. And that's not really something that privacy lawyers talk about. You don't have to be a consumer to have data privacy. You don't have to buy anything. You have it already, right? So the language is quite distinct. And I think the concepts of what is good for consumers and what is negative for consumers has to be reconciled in some sort of way at both the policy level that we talked about and then the interagency operation level. And so there's a lot of work to be done here. The stronger privacy law gets, and it is getting stronger, the more competition law is going to have to address it.
Wonderful, thank you. And Francesco?
I completely agree about agency cooperation. I think this is the first important step. I do not think that agency cooperation requires competition law to have a standalone objective that is privacy, especially if we see the creation of a new tribunal that deals with privacy and data protection through Bill C27. I see these two institutions dealing with their specialty and then cooperating in cases where there is an overlap. And from the competition policy side, I really see privacy mainly being a dimension of non-price competition, where both academic literature and case law can provide some starting points how to think about the trade-offs between again, privacy competition and quality. But I would say we're not starting from zero in this area.
Yeah, I think there are a lot of difficult questions that are going to have to be addressed in the coming short while, and I don't think there's any easy answers. There's this tension between privacy and anti-competitive conduct. You know, the fact that privacy is not always aligned with quality. I think there's lots of difficult questions that we have to think through, and I don't think there's any simple answers, and I don't think simple rules are the way to go forward on this. As I'm not an expert on competition and privacy at all, but I've learned an awful lot from the both of you. So thank you very much for everything today. I will turn it over to Josh Morrison, who is the head of our Future of Law Lab, who has some concluding remarks.
Thank you very much, Anthony. Well, first, I'd like to say thank you so much for a riveting discussion. Anthony, Francesco, Erika, we really appreciate you sharing your expertise and insights with us. I'm already seeing some comments come in. People really have loved the discussion, and this is obviously a very topical area right now. For everyone still in attendance, I'd like to point out quickly, this may interest you. We've also recorded another session on the competition consultations, and that will be distributed shortly. So keep an eye out for that when we brought on a number of fantastic practitioners to kind of give us some of their opinions about the consultations, and we'll be sure to share that with you as well. So thank you very much, everyone, for joining us today. Thank you again, Francesco, Erika, and Anthony, and Julissa as well for helping us put it together, and have a fantastic day.
Thank you.